When you get to your judge or when you get to your jury, what is it that they can do for you? I showed you an example earlier of a writ of ejectment, or may also kind of be thought of as a writ of restitution. So that would really be specific relief. You are seeking ejectment, you get a writ, sheriff serves it, that person is gone. That certainly is what um, your primary request in that sort of action is. But courts can do more. Specific relief in a quiet title action is more along the lines of that declaration that we talked about, declaring who the proper title owner is and what their specific rights are. But courts can also do other things that are more along the lines of specific relief, but also, I guess, are equitable in nature. Citing to Robinson v. Kahn here, certainly conceivable the court can cancel a deed or declare that a prior conveyance is invalid, or order that a legal description be corrected. And the case I've cited here, the Court of Appeals stated that it was reversible error that this particular judge did not enter an order to basically record a document stating that a prior deed was invalid. So that was a very specific remedy that that the Court of Appeals found should have been undertaken by this court in order to, truly clarify the title change. But of course, a lot of this does come from equity, and we know that when you say the word equity or equitable relief to any given judge, sometimes that means, well, I can pretty much do anything that can pass the smell test. And I think that that does certainly fit into these sorts of requests as well. And so there very well be very specific requests that are germane to a given action, that may not seem to relate directly back to the statute. That I don't think it's unreasonable to ask a judge to grant, and that many judges likely would grant if they deemed it to be something that was fair, something that was reasonable, something that promoted clarity, and ultimately just sort of was just an equitable relief as would be required in any sort of equitable action. Point being, there's a lot of discretion, especially when one of these cases is going to be tried to the bench. Within any of these sorts of actions, the statute specifically provides that a special master, a referee, I think the statute also, or another statute, or perhaps this court rule, refers to this sort of individual as a commissioner. But the court has authority to insert someone into the process to be their boots on the ground, as it were. A referee or special master or commissioner can execute deeds, can execute purchase and sale agreements, can sign real estate excise tax affidavits, can record things, can resolve disputes and report back to the court. There's a great discussion in the case cited here, Levine v. Green, 106 Washington Appellate 12. And then I've cited to some of the statutes that talk about authorization for getting a third party in there to actually affect real world change in these sorts of cases. And I didn't cite to it, but I do believe that the statute itself, 728 also has a provision that talks about either a special master or referee or commissioner, or certainly just states that the court has authority. I think in 728 it doesn't use one of those names, but does provide that, hey, we can insert someone in here to affect the orders of the court. This was talked about under an earlier slide, but the statute specifically says, and I think this is what maybe I was getting at a moment ago. I believe this is the last sentence of the statute. It says the court may make or cancel any deed or conveyance of whatsoever nature or do any other act to carry into effect the judgment or the decree of the court. So again, great discretion on how a court can work to, again, restore possession, clear the cloud on title, figure out where the boundary line is, or affect any other sort of relief in a real property action. And referencing injunctions here as well. Now, an injunction's not going to be specific to 728, but specific to, CR 65. And there's any number of reasons that a preliminary injunction, a temporary restraining order, might be necessary in one of these actions, especially if it doesn't appear that default is going to be the result, or it may not be feasible, that this is a summary judgment type case, and you've got a plaintiff who's going to be in this for the long haul. Some form of temporary relief is likely going to be necessary depending on the circumstances, and your path towards that temporary relief is going to be an IRO or preliminary injunction. Anybody have any experience getting a preliminary injunction in one of these cases? Damages. This is why we're all here, right? Money damages are available in ejectment actions. And the measure of damages is typically the value of use and occupancy during the wrongful possession. Typically, that is going to be calculated by some sort of rental estimate, if it is just, say, a holdover or someone who is just unlawfully possessing, and you don't have a lease, right? I mean, a lease would certainly establish what the reasonable rental value would be, but because often in this sort of action, we're not going to be dealing with a lease situation, some form of estimated rental income is what the court is going to look for. Double L Properties versus Crandall, 51 Washington Appellate 149, specifically ropes in attorney fees as an element of damages in an ejectment action. The ejectment statute does not have a specific fee provision. And one who is going to seek fees in a ejectment or a quiet title case is going to have to take a look at a case like Double L Properties, and there's a number of cases that talk about attorney fees in this setting, but it's not statutorily authorized. And because we're not dealing with a lease or a contract, typically, there's not going to be a contractual fee provision. So it will take some care and planning to make sure that you have properly pled and proved the basis for fees. And it's going to be worth your time and effort to take a look at the line of cases that talk about how attorney fees are going to be awarded in one of these actions. Quiet title in the alternative do not generally provide for monetary relief. The remedy is declaratory and equitable in nature. We've talked about that a fair amount of today. Cited a case that stands for that proposition. However, there's a number of cases out there that tell you there is a mechanism both to seek fees and to seek financial damages under a quiet title theory. And that is if you are able to plead and prove the separate tort claim of slander of title. That's something that I don't have direct experience with, but the case I've cited here contains an excellent discussion about how slander of title might apply in this situation, how it is pled, and what must be proved in order to get you to financial damages and recoverable attorney fees. In that case is Rory v. Douglas, Washington Supreme Court, 1994. I'll tell you that there's also a number of other cases in this line that talk about slander of title and how damages might flow from being able to prove one of those claims. I think the takeaway for the purposes of today is just to know that quiet title in and of itself isn't going to get you there for damages and fees. So you need to take a look at this additional tort. Anything to add from anybody who's pled or tried one of these cases as to how to calculate damages, how fees are awarded, etc.?
I will say that there is at least one commissioner in Pierce County who says that I'm not entitled to attorney's fees. And I've been kind of around and around. And the reality is my clients are so happy to usually get their property back that they don't want to spend any more money on reconsiderations or revisions to get it. But that there are commissioners who say we're not entitled to it under the ejectment action.
Attorney Powell, I saw a hand raised.
I did. What I wanted to say that, okay, and in response to the previous client person who was talking, how would you be in front of a Pierce County commissioner as a default in an ejectment? That would make sense. But if it was resolved by an MSJ, be in front of a judge. So if it's a default, all right, that makes sense. Okay, and what I was saying too is that ejectment is an ordinary civil action. It's not limited to just purely the issue of possession, the way an eviction is. And what that means is that if a ejectment defendant wants to file a counterclaim, they can.
Mm.
And so that's the big difference. And that was a reason not to file actions as an ejectment unless there was a really good reason. And I see nothing in 728 that is specifically allowing a plaintiff who may or may not be a landlord to recover any kind of attorney fees. It's not there.
It is not there. It is
Yeah.
not. And that's why I would point you to that double L case because
Yeah, I'm gonna go look that up.
it's a measure, it's part of damages. It's not a fee provision.
Right,
And that's why I'm saying is that if you are going to go down that road, you need to very carefully and appropriately frame it as an element of damages because yeah, you do not have a fee provision in 728.
right.
Now there may be some other equitable basis for fees. Sort of overly litigious or bad faith litigation or one of those other theories that isn't specific to 728. But in cases that discuss 728 to get to attorney fees, again, it's under the theory that it's a damage.
Pardon me, Mark.
Mhm.
Attorney Powell, you had a question in the Q&A, and I wanted to make sure that that was actually answered. Your question was, but consider that ejectment is an ordinary civil action with where a defendant can bring a counterclaim, unlike eviction. And I just wanted to make sure that that was addressed. And thank you, Attorney Powell, for putting in the RCWs.
Okay, we did address the idea of a defendant creating a counterclaim in an ejectment. And then there was a mention of, all right, where's another place to get attorney fees? And it's one or the other. It's either 484, 183, or 330, and I can never remember which is which.
Yeah, as I said, some of the equitable theories that are cited too, again, reduction of a common fund, bad
Right.
faith litigation, intransigence, those sorts of things.
Yeah.
But I think that your point is probably worth underscoring, and that is an ejectment, a quiet title action, anything we're talking about here is just a civil action, and all of the rules of civil procedure apply. So, whereas the summary unlawful detainer action is very limited in scope and is also sort of procedurally narrow, you as a plaintiff in an ejectment action, you are subject to counterclaims. Someone may bring in a third party defendant. There may be cross claims. There's going to be discovery. You may be dragged into a deposition. You may have subpoenas served on you. Sort of all of those things that go along with civil litigation are going to be present in ejectment, and a client does need to know that, again, because somebody's going to walk into your office and think they're talking about an eviction that's going to take 20 days. And it's just an entirely different ball game.
Evictions took 20 days in 1992. They no longer take 20 days, believe me.
Yeah.
That's on the part of the landlord bar.
Yeah. Yeah. Understood. That was a bit facetious, but I think that's, people do have that mindset that, hey, this is gonna be something quick. I just got to put this notice up, and the sheriff's going to come the next day and yard this person out of there. And it's that mindset that will need to be realigned with realistic expectations for a lot of people. Certainly some clients, and I'm certain that your average Pierce County landlord or City of Tacoma landlord in 2026 has no such misconceptions about how an unlawful detainer is going to work. All right, so sort of to wrap it up here, ejectment restores possession. Quiet title clarifies ownership. That's at the very high level. There's a lot of nuance there and a fair amount of overlap, but that's sort of the big picture takeaway. All of this comes out of 728. There's a whole lot of other legal actions that you will also find in 728. Those actions, such as adverse possession, are also going to affect. Hang on. Yes. So that's where I'll conclude. I'm really appreciative that there's some folks out there that have got some excellent experience and were able to share some very interesting and thoughtful experiences that they've had. I'm happy to answer any other questions that people might have. Or I would float any question to some of the other practitioners here that clearly have got a lot of experience in this area of law. I see Suzanne Thompson with their hand raised.
Yes. Can you hear me okay?
Yes.
Okay, great. So I'm Suzanne. I'm actually a guardianship attorney, and we deal with a lot of these things, unfortunately, in guardianship as well as probate. But this is more practicality end user, just hypothetically. With a, I've been involved in a case with ejectment. There's already there was a summary judgment, ejection is appropriate, but it happens to be somebody with severe mental illness that has lived in the house for a very, very long time. And lots of different things were tried before that. I promise you, we've considered guardianship, and I was a litigating guardian ad litem. So the court already found that there were issues capacity wise. But what I'm curious is when the writ is actually issued, has anybody had experience like how do you physically get that person out of the house? And I see it going one of a couple ways. She's not going to go willingly. But more importantly, you know, if the police are called or that's part of the writ and they go to remove her, it's not going to be a pleasant thing. And there could be an arrest, there could be an involuntary treatment. It's just a terrible end result. But just wondering if anybody has other practical tips with the best way to handle that. And there are no good answers, I don't think, in this one. I promise you it has been vetted. There have been many court hearings. The court's doing the best it can, but I know I'm going to be on the end of that.
My most recent experience with having a writ served involved a very similar situation. This writ was issued in a probate, and there were heirs that were squatting in estate property, and Judge Peñalver ultimately issued a writ of ejectment, and we were very much worried about the same circumstance. The individuals that had been there for many, many years were in poor health, and we sort of, it sounds like, did the same approach you did, sort of stalled and delayed and hoped and crossed our fingers. But ultimately, deputies went out there. Thankfully, it was these people knowing with certainty that the deputies were going to be there that was the final straw that caused them to vacate. I'm going to use the word voluntarily. That's not the right word, but it was the deputies literally being on their way that caused them to walk out the door on their own. So we avoided what you're worried about. And I guess all that to say, as I understand the concern, but don't know that there's any better answer than letting the police do their job.
I agree. That's super helpful. I always feel like what I'm dealing with is what I'm dealing with, but I work a lot with Steve DeDavo, so he and I have a lot of interesting cases like that. But no, that's helpful. And again, I'm working with her trying to find a new place to live, and there's a variety of things, but I think when push comes to shove, I agree. The writ's going to be what it's going to be. We can't control a lot of things, and it's going to play out how it's going to play out no matter what we do.
Ms. Winiger, is your case in King or Pierce?
Oh, you had to ask me, give me just 2 seconds. It is King.
Okay, all right. There is an email address for the civil part of the King County Sheriff's Department, and I think it's civil.kc. So I don't remember what it is, but you can look it up. Okay. There is no reason why you cannot send an email to these people, to the Sheriff's Department, and say, here's some stuff you need to know about what's been going on, and tell them if you think it's a mental health issue, if you think it's a drug issue, if you think anything like that, And that will give the sheriff the opportunity to bring in the type of social worker types who can offer that person some assistance if necessary. I had this happen a couple of years ago in Pierce, and I was filling out the law enforcement information for the sheriffs when we submitted the writ, and the sheriff's department sent three social workers.
Oh, okay.
I know it was great. It was people who were
Yeah.
there to support this person. And the way that happened was because I let the sheriff know that I thought it was really important that somebody be aware of what was going on. Because I don't want anything to happen to that person, you know?
Exactly. And that's
Yeah.
super great advice. I had not thought of that. So thank you.
Okay.
Well, if anyone has any final thoughts, now is the time. It is 1:27, so it's time to do our wrap up. But I'm just going to open it up to everybody. If anybody has any final points, please do. And that includes you, Mark. Thank you.
I do have a quick kind of question. I'm gonna have to move to eject people that had been taking care of a deceased. He's now deceased, but they were taking care of him for quite a long time. He bought him a fifth wheel trailer. They currently reside on his property, but have never lived in his house, paid rent, utilities, anything, didn't even buy the trailer. And so I'm gonna get an ejectment action going. And kind of once that happens, has anybody dealt with once you get the writ and potentially get the police involved or the sheriff's office, d- do you kind of have to take charge of getting a tow company, or is that something they can assist you with? Because I just know that these people will not have any ability to tow on their own.
The way I've tended to handle those is they were working for the people. They're under the RCW 5912. An employee is given a 3-day notice to vacate after termination of the employment.
That is good to know. Thank you.
Well, I don't
Mark?
have anything further, and it looks like we're about at the end of the time allotted. So, Amy, thank you very much. I hope this was helpful. It was really great, as I said a few minutes ago, just to have everybody chiming in, and I think I learned quite a bit today, and I hope everyone else did as well.